Welcome everyone. It is Tuesday night, the 21st of March. I'm Kelly Wilkins and this is the Coimbra Connections. We call it that because Coimbra means happy place. And so this is the My Self-Reliance Zoom call. We meet here every Tuesday night. And we have a special guest speaker with us tonight. It's Michael Schultz-Rolfe from I'm going to go
live
to
in
your
private.
Living in private. Thank you, Michael.
Live in private. Lip, L-I-P, lip. Live in private. It's a Telegram channel. You'll only find me on Telegram. It's a Telegram channel.
There you go. And if you're in the room, Michael has put his link to the Telegram channel in the group. So LIP, live in private, and maybe put the link there, Michael.
The link's there. The link is there. If you scroll to the very top, of the comments, it's up there.
Perfect.
You can just click straight on there. It's the second message in the message, the meeting chat.
And hopefully your internet's going to play nicely because it's actually just a bit unstable at the moment. There you go.
Yeah, it's always like that when I'm on Zoom for some reason. Maybe I'm being watched and they don't like me sharing information.
Could very well be the case. So right before you get started, Michael, I just wanted to take the opportunity to welcome everyone that's here tonight. And you know what, as we've been preparing for this call, a few thoughts have come to mind. We have been all waking up at different times in this journey these last 3 years. And as we do so, we come to realize that there's things that we believed or thought we knew previously that are really starting to shake up our belief systems, which is a great thing because human beings are very malleable when it comes to belief systems. And, when we're taught as a young child, we're taught certain things, and those thoughts and ideas shape our actions. But as we go along, we actually need to rethink some of our belief systems. And because some of them are serving us and some of them are not serving us. And it's really important that we start to question ourselves when it comes to our belief systems and the way we think and the way we respond, so that we are starting to move along together in the upwards direction. And I really believe that personal growth is really important at this time in our progression. One of the things that I teach in my course, the Jigsaw program, Jigsaw is a morning routine. It's a morning method that is all about having routines that really serve us and promote a good morning power hour so that you start the day well. In Jigsaw, it all stands for and it's an acronym for how you can do a morning method. And the I stands for inspiration, meaning that every day we need to inspire ourselves with new knowledge that helps us progress. And so as we jump into this topic, any common law topic, I feel like we have to evolve to become new in our way of thinking, so that we actually address the concerns that we're seeing and coming up against with a new way of thinking, a new way of doing things than what we have before. Because I feel like in the freedom community, we're all on different levels. It is going to take a different way of doing things and as we move forward. And so what we thought that was possible. For example, a year ago, I thought that overseas travel was probably never going to be possible for me again. And so I ruled out the idea that because I'm unvaccinated, I'll probably never get to go on a plane again. I'll probably never get to go overseas. And that a year later is not true at all. Right. So I want you guys to, as we start to have this conversation, is just peel back some of the belief systems that you've had around what we're experiencing, what we're going forward with, and really start to examine for yourself what is possible and what's not. And so we're going to jump into our topic tonight and welcome Michael, because who knew? Well, some of us knew that we could really address the legal system in new ways. And so, Michael, handing it over to you. Thank you for being here tonight.
Thank you. Yeah, thank you for inviting me. Yeah. I hope not to bore anybody, but I'm just going to read some notes that I've taken over the course of the few weeks preparing for this. So I'll try and get through it as quickly as I can. There's three parts to it. One, I'm going to explain fee simple for the property owners who would understand what fee simple is, and how it works within our country. And then after that, I'll just touch on the castle rules, and then the actual council rates itself, the sort of questions that you can ask your council to find out what claim they have on you and what authority they have to actually send you the rate notice in the first place. Australia is a common law country, and property owners have rights at law, particularly through the High Court ruling by Mr. Justice Kirby in September 1998. Property owners whose land is held under deeds in fee simple have the right to refuse to agree to the takeover of their land for this or any other purpose. Property owners' rights in Australia are guaranteed in three ways by three different legal instruments. One is deeds in fee simple. Two is the Magna Carta 1215. And number three is the Bill of Rights 1688 or 1689 as referred to. Fee simple rights, particularly the High Court ruling given by Mr. Justice Kirby in September 1998, when he made his decision by using an early High Court case of 1923, when Mr. Justice Isaac settled a dispute by confirming to the property owner in the case the rights conferred on all property owners under their freehold deeds in fee simple. That was a very important case because it actually was the first case that challenged the property ownership since 1901 Federation. As you know, Queen Victoria, when she gave us a self-governing, that she also gave us our land rights so obsolete that even any royal who comes to visit you must have your consent to put 1 foot on your land. That's how important our fee simple is. That's how much power we have over our own property. No one can dictate anything to us. Under the current laws in Australia, both state and federal, it is absolutely illegal for the government to take what it wants, or indeed to dictate in any way what property owners must do or not do in regard to their lands held under deeds in fee simple, so long as we attain our common law status under our legally unchangeable Christian monarchical constitutions, which apply both state and federally. Monarchical constitutions is referring to our Constitution 1900 UK and 1901. Certain politicians are trying illegally to change our unchangeable federal constitution because they want to deny people the right to hold private property under our monarchical laws. And I think we're all witness to that. That's what's been going on, especially since COVID. Evidence of present protection of our rights through fee simple and it starts in the High Court of Australia in a decision in the case the Commonwealth versus New South Wales. Justice Isaac spoke of fee simple as follows. In the language of the English law, the words fee signifies an estate of inheritance as distinguished from a less estate. A fee simple is the most extensive in quantum and the most absolute in respect to the rights, which confers of all estates known to the law. It confers, and since the beginning of legal history, it always has conferred the lawful right to exercise over, upon, and in respect to the land, every act of ownership which can enter into the imagination, including the right to commit unlimited waste, and for all practical purposes of ownership, it differs from the absolute dominion of a chattel in nothing except the physical indestructibility of its subject. Besides these rights of ownership, a fee simple at the present day confers an absolute right, both of alienation inter vivos, and of device by will. So basically what he's saying is that in that High Court agreement, you as the landlord are the king and queen of your own land. There's no one above you. No one has right over your property. You have no obligation to listen to anybody unless you consent. Most non-leased properties in Australia are fee simple, and therefore the majority of property owners have rights that override any government department or any municipal council. Unfortunately, many landowners are not aware of their rights. There are also other court rulings such as Plenty versus Dillon in 1991. I suggest everyone actually Google that and actually read it. I'll just repeat it. Plenty versus Dillon in 1991. And parliamentary legislation that further confirmed the fact that property owners in this country have the law entirely on their side. So if you didn't want to pay rates, don't pay them. You've got the law on your side. Okay, the Plenty versus Dillon in 1991 was a High Court of Australia, states in part, and there's three parts to it. So we'll go through each one. Consent to an entry is implied if the person enters for a lawful purpose. In Robson versus Hallett in 1967, the occupier of any dwelling house gives implied license to any member of the public coming on his lawful business to come from the gate, up the steps, and knock on the door of the house. This implied license extends to the driveway of a dwelling house. What he's saying there is anyone coming to your front door has the benefit of doubt to actually have business. If they think they have business with you and you might be interested in that business, then they have that right to come to your door. However, the license may be withdrawn by giving notice of its withdrawal. A person who enters or remains on property after the withdrawal of the license is a trespasser. Now, what they mean by that is it could be you yelling from the fence or the gate to get off your property, or I'm not interested, go bugger off, or you've got trespass signs displayed at every entry of your property. That's what they mean by license. When you have a license displayed, they need your consent to come on your property. If you have nothing displayed and no signs that says trespassers, you're trespassing if you come on your property, then they have that legal right to come to your door. Okay, a person who enters or remains on property after withdrawal of the license is a trespasser. That's automatic. Trespass law in this country is brilliant. You and I, everyone can count on it to win in court. And I'll explain a little bit more about that later.
Michael, do you need 3 signs? 3
Usually,
per-
it depends. Depends on how many accesses you have. If you're on a property and you've got all fence all the way around it and you only got the one gate, then you only need it on the one gate, right? And on the gate and also on your front door. If you're an open suburbia house with no front yard, with no front fence or anything like that, then like my house, for example, I actually have a front veranda. People have to climb stairs to get up to it to get to my front door. Well, I would have one displayed at the end of my driveway. Also on my gate, which I actually separate my backyard to my front yard, and also one on the door, and that's 3 signs. You should also have it locked. And believe it or not, a cop who comes on your property will go through your gate because he thinks he's got access. The moment you have, if it's locked with a padlock or something, and he has to climb that fence, knowing full well there's a lock on there, by default, he's trespassing. You can actually sue him.
Right.
Right. Okay, so in Davis versus Lisle, it's Lisle, 1936. So that's Davis versus Lisle. Police officers who had lawfully entered a garage for the purpose of making inquiries were held to have become trespassers by remaining in the garage after they were told by the proprietor to get outside. So the moment the proprietor says, you must leave my property, get off my property or whatever, the police must leave. There's no staying. They must leave at the quickest and shortest route, right? There's none of this, you've been warned 3 times. It doesn't count. If you have absolute over your property, it's not to be argued with. They just don't have any business being on it. They have no jurisdiction. And that applies to your car. If you're driving along minding your own business and they decide to pull you over, and for whatever excuse they've got, which is usually none, they will they want to reach into your car, grab your keys so that you don't drive off, or if they open the door so they can grab you and pull you out, that's trespass. If they don't have your consent to deal with you like that, that's trespass. You can actually sue them. Yeah, so the second one is the general policy of the law is against government officials having rights of entry on the private property without the permission of the occupier, and nothing concerned with the service of a summons gives any ground for creating a new exception to the general rule that entry on property without the express or implied consent of the occupier is a trespass. And now that's just recapping on what I was saying before. They have no authority. They have none. 0. They might talk like they have, they might claim like they have, but they have none. All right? It's like the state police have no jurisdiction on federal road, on Commonwealth roads. They have none.
So we just, before we get too far ahead, so renting and living in apartments or units, is it same applies?
Yeah, the same rule, geez, my reception's bad. The same rule does apply. They must have your consent to enter the premises. You're renting or leasing, so you have it. You don't have fee simple, of course, but you still have the Privacy Act. You still have trespass laws. No policeman can come into your property and demand anything from you just because he's got a uniform and a gun on his hip. He doesn't have that. That's not the authority that he has. And even if he's got a warrant, that warrant has to be legal. There has to be a name and a signature on it, and it also must accompany an affidavit by the claimant. The complainant must have an affidavit with that warrant. What they've been doing these days is circumventing all that and saying, yeah, we've got a warrant, but it's back at the office. We'll show you when we take you in. It's just not good enough. You tell them to leave, go away. You've got no authority here. They've actually committed a crime. It's important you sue these bastards. They're getting away with this because no one's suing them. Okay, and the third one is, if the courts of common law do not uphold the rights of individuals by granting effective remedies, they invite anarchy. For nothing breeds social disorder as quickly as the sense of injustice, which is apt to be generated by the unlawful invasion of a person's rights, particularly when the invader is a government official. Now, we've all felt that, and we're seeing it. We've seen it on TV, YouTubes. We've seen the behaviour of these officers is getting worse and worse. They're tyrannical. The government thugs. They think they're above the law. They're behaving like they're above the law. And they've got some sort of power over you, like you're their slave. That's just not the way. In trespass law, there are 3 categories that you need to assess each interaction with a public official, because this is money to you. You're making a price list in your head, all right, as you're interacting with them. Trespass covers 3 subjects. One is trespass on your person, so your body. Trespass on your property. So there could be property damage, property theft, taking of your phone, that sort of stuff. And then there's freedom. Trespass of your freedom, driving along, minding your own business, and they pull you over for no reason. There is case law that establishes all our rights. We just have to find them, learn them, and use them when the occasion arises. It's not that difficult. All right, the Australian Constitution incorporates the view that the individual freedom should prevail alongside a limited role for government. Section 51 requires that if the government acquires property from any state or person, it does so on just terms. Just terms have been defined by the High Court as full and adequate compensation, where the acquisition is a compulsory taking. Now, this is in my neck of the woods. This has been going on for the last few years with the building of the second airport. They've acquired so much farmland that they virtually bullied themselves in and just demanded that the state acquires the property, and the participants were unwilling, but they fought a good battle, but they lost in the end. I mean, who wants an airport in your backyard anyway? I'm assuming they all got well rewarded. I know a particular piece of property that had the market value of $3 million at the time, sold to the state government for 30. Remember, this is our taxpayer dollars. And it wasn't until later that it was found it was a corrupt deal. It had involved a politician and everything involved in it. So yeah, he obviously had his little take from it using taxpayers funded money. This is the sort of corruption that goes on. If it's not reported on the news, you won't know about it. Now, Section 51, the acquisition of property on just terms from any state or person for any purpose in respect of which the Parliament has power to make laws. Now, that's all good and well because Section 51 comes out of the Constitution, which is a royal assented act for constitutional government. The problem we have is we don't have a constitutional state government operating. So when they come to your door demanding that they seize your property for the betterment of the town or the community, they actually don't have the authority to do that because they're a corporation, they're not a government. So there's a bit of a conflict there. However, it must be noted that Section 51 only applies to the Commonwealth. It does not bind the states, nor do the states have just compensation clauses in their own constitution. So it's only the Commonwealth that can take your land, it's not the state. But keep in mind, our Commonwealth and state aren't constitutional, they're corporations. So they're pretty much doing whatever they bloody like because they're not following the law. They're not following the constitutional law. For this reason, the argument that Section 109, this is of the Australian Constitution, that's another one you should look at, takes precedent over the state constitution is unassailable. So in other words, 51 doesn't apply because for the state, because 109 says in the Australian constitution that the Commonwealth can only take your property. Section 109, when a law of a state is inconsistent with a law of the Commonwealth, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. So in other words, if a state law conflicts with a Commonwealth law in the Act, the Commonwealth prevails. So the state has no control, no power, no authority or claim over your property without your consent. Okay, property rights are essential to freedom, justice, peace and prosperity. They are basic rights. Despite common law and constitutional protections, property rights are increasingly being eroded by the modern regulatory state. The time has come to restore respect for property rights for all landowners. A trespass notice is in fact a withdrawal notice for the common law. Implied license to any member of the public coming onto his lawful business to come through the gate, up the steps, and knock on the door of the house, and must be clearly displayed at each access to a fee simple owned property. So if you're a landlord and you've got tenants in your property, it doesn't stop you putting trespass signs on your property, because only the tenants have the right to be on their property anyway. So that's fee simple. The good news with fee simple is you're probably aware that the government in their wisdom have ordered all the banks and everybody else to destroy all our fee simple titles, to go electronic. We did at one stage, till recently, thought we would have to class action and sue the state governments for destroying our private property, which we still plan to do. But they've taken one aspect out that we were actually last going to do was make them actually replace those titles. We don't need to do that anymore. There's a group that has Royal Assent, who have just about to open up a land and title office in Victoria. And for $180, all you have to do is submit your folio number of your title, to them with 180, and they will reissue you a Royal Assented property title. So what the banks have is rubbish. What the Land and Title Office has is rubbish. We're all going to get our titles back in hard copy. There's a bit of a sneak there, surprise for you. Okay, so where we are, we've got this one, so that was that. Okay, now talking about castle rules, or castle rules. Yeah. There's castle rules. An Englishman's home is his castle, and an assault on the castle is a recognised act of war. This is going back centuries. This is how it was. It was anyone that attacked your house was actually declaring war against you, against your property, trespassing, to steal and pillage your property. In a time of war, then the casualties of war are just that, the casualties of war. He that knowingly enters into an act of war, knowingly or unknowingly, has still entered into an act of war of his own volition. The occupants defending the castle cannot be held culpable for any casualties of war, even though these casualties of war should end up dead. This is recognised from the historic traditions of this land. Now, we got a modern version of that. It's called self-defense laws. We rarely put that into practice, but there is case law that actually backs you up. And an example would be on one of those case law is where a farmer refused entry for a police officer who wanted to serve a summons on him. The police officer came onto his property. He was constantly, repeatedly warned to leave, not to get off his property. The officer was belligerent, arrogant, and thought because he was wearing the uniform and the badge, he had the authority to go anywhere where he pleased and he could come onto his property and do whatever he wanted. And that farmer shot the cop to maim, not to kill, to maim. 2 years later, the farmer was free from it all. He won his case. The case she set a precedence. What that lesson was through that court was other cases, case lawyers. You as the landlord of your property have the right to self-defend with whatever means necessary to subdue the attacker, the invader, or the home invader. Now, if they're injured in the process, then that's bad luck. So long as if he comes at you with a knife, you don't shoot him, or if he comes unarmed and you go and stab him, you can't do that. It has to be equal force, but just enough, just a bit more, so you can subdue him, hold him for the authorities to come and get him. Now, if the authorities arrest you in the process because you are defending your home and your family, and they arrest you and treat you like a thug, like a criminal, you can sue every single one of those officers. So keep that in mind. The Castle Doctrine, also known as Castle Law or a defence of habitation law, is a legal doctrine that designates a person's abode or any legal occupied place. For an example, it could be a vehicle or a workplace, as a place in which that person has certain protections and immunities permitting him or her, in certain circumstances, to use force, up to and including deadly force, to defend themselves against any intruder, free from legal responsibility, prosecution for the consequences of the force used. Typically, deadly force is considered justified and a defence of justifiable homicide applicable in cases where the actor reasonably fears imminent peril of death or serious bodily harm to him or herself or another. So in other words, if you're a 70-year-old woman living alone in your house and some thug comes into your house to rob you and hit you in that, no one's going to blame you if you shoot him dead. If you're a young man and another young man came into the premises, then you would have to make a very careful decision as to how you're going to tackle the situation. But as an old person, you are limited with your strength, agility. You do need to reach for something a little bit more protective. Even a dog, get a dog. They make great pets for protection. Yeah. So you just need to weigh up the pros and cons of your actions. But at the end of the day, like it says, if you fear for your life, if it's a clear-cut trespass, uninvited, and they will warn, then you have all the right to subdue that individual to the best of your ability so he no longer is a threat. So a little bit more force is acceptable. Keep in mind, if it had been a common law constable that came to your house after the event, and he would leave you alone and walk away with the crim or do the best he could with the crim. But these days we've got security guards dressed up as police officers, law enforcement, and they don't care. They'll arrest everybody in there. They'll throw you in the lockup. They'll get your names and everything. They'll send you a fine, and the whole idea, the purpose of their existence is actually process you through the court system so that the court can charge you money. That's what it is. It's just a whole system of stealing from your pocket. So any Crown authority stops at the boundary of the property. To proceed beyond this point is a recognised act of war. This is trespass. Act of war is trespass. So that just made my point, what I mentioned earlier. They can't come on your property unless you consent, and you must tell them you do not have my permission to put 1 foot on my property. I am the fee simple landlord of this realm. You have no authority or jurisdiction to enter it. If you make that sort of clear for their little body camera, you got a lawsuit if they come on your property. And we've had an example of that recently. And a lady walked away with plenty of money, all because the copper put 1 foot on her property when she asked him to leave it, and he was being belligerent. So she said, "Okay, sit yourself." Went to the Supreme Court and she won. Or because the judge asked him, "Did you put your foot on a property?" And he said, "Yes." He says, "Well, you owe her." That's it. Okay, now, okay, so where no such legal agreement exists, then the bailiff, who is only a bailiff by title, has no powers of entry unless the authority can be presented in the form of a legal agreement, which must contain upon it 2 wet ink signatures, one of which must be yours. Now, this is where we get interesting. We've gone from trespass, self-protection, and now we got some idiot who thinks he's king with an unlimited license bailiff who thinks he can come on your property and seize your property. This is foreclosures and things like that. They got nothing. No power whatsoever. They got nothing. And they must have, if they do have the bailiff conditions, they must have all the documentations. And as recently as maybe 4 to 6 weeks ago, with Rod Cullerton in the Supreme Court in WA, he proved that point. The court was scheduled for a 2-day or 3-day trial. It only lasted 6 minutes, or because Rod Cullerton proved that the bailiff had no authority whatsoever to do what he did. The problem is that particular bailiff was also the same bailiff that stole his property for the bank a few years earlier. And you can imagine the damage that bastard has done and the foreclosures that he's done over the years when he had no legitimacy to do it. They're not Commonwealth officers. None of them. Not one politician, not one judge, not a lawyer, not one cop, not one council employee. They are not Commonwealth recognised officers. They have no authority and no jurisdiction over you and your property. I can't make that clearer. Yeah. Now there's a lot of
Just before you go on too further, there's a few questions coming through with the chat, so I don't want to get too far ahead before we address some of these questions coming through.
Okay.
Because you'll change the topic in a moment. And just on what you just said, that you know, that they want us to deal through the courts, but also we want to deal with them through the courts, don't we? We don't want to really have that confrontation on the porch. We want to go through the courts.
Depends what court.
Yeah. Okay.
What you want to do is, if you even get a smell of them wanting to foreclose on you, you gather the information that you have, and you make the claim first in the court, so you're the claimant. Because once they claim first through the court system, you are now the defendant. It's a harder stand to get out of as a defendant than it would be as a claim. But you're not claiming against them to stop them from foreclosing on your property. But you're doing a civil claim for damages. You're suing them for even suggesting, to even think they've got actually authority to steal your property, because that's trespass. That's trespass of your property, and that's trespass of your freedom. Remember, we as landlords of our own realm, which is our property, fee simple property, your property guideline borders that's your realm. You are sovereign on your own land, right? They have nothing. They can't touch you. They can't do anything. And remember, this is a corporation who are conducting business. This is business. They're not conducting the law. They're not conducting constitutional law and rights. They're conducting a business. The first question you would ask is, what authority provide the material evidence that you and I have a contract with both wet ink signatures on it that says that I gave you consent to foreclose on my property, because they don't have any. That's why you must go in first with the claim. You know, you do that.
Yeah, going back to the question we had earlier about, I think it was around, Gads was asking a question around having that bit of paper on your property. How does it affect your mortgage? Mortgaged properties. Is that right, Gads? You might want to be more clear, because it was a little while ago that you put that question
You
in.
mean what your right? What they're asking what your rights are if you have a mortgage on your property because the bank has your title.
That's right.
Okay. Well, the bank should never have had your title. They don't have a right to ask for it or even sit on it or hold it. It's not your property they're buying. They're lending you money. Well, in their view, they lend you money. It's all fraud anyway. But they have no actual right to hold on to your title. What are they going to do with it? The title wasn't that important. Why would they be so desperate to hold on to it? Because back in the old days, when we didn't have computers and we had a gentleman's agreement between the people we knew in circles, he who holds the title owns the land. That's how it used to be. If you have the title in your hand and you give it to your brother now owns the land. He's got the title.
Yes.
That's how it was passed. And property transfer or ownership of transfer was a bill of sale, no different than if you were selling a car.
Mm-hmm.
Bill of sale. It was none of this rubbish that the corporation created. This is all their made up stuff. They're made up fiction. Right? But a bank lends you money, which they don't lend you actually cash. There is no cash transfer. So this is where the fraud is anyway. That's another topic. But they don't have the necessity for them to hold your title. It's not necessary. They don't need it.
Thank you for confirming that, Michael. I guess the next question to follow up with that is this land and title office that opened in Melbourne, does that apply in New South Wales as well?
It's everyone in this country can now get their land title back.
So even if we reach out to, and you guys have the contact details for the land and title office that's being established in Melbourne, to share that with everyone.
You will know shortly. Give us a chance to open up the office and get it staffed and furnished.
Wonderful, thank you.
Right.
Thanks a lot, Michael.
But it is royal. I might say it is royal assented. Okay, we have royal assent. Now we have royal assent. We can do a lot more with it too. We're not only looking at land titles. All right. We're looking at removing rate notices. We've already got established our own councils, our people's councils. So there's a lot we can do. We can actually employ our own police force if we wanted to. We can do everything with royal assent because we are the highest authority in the land. The rest of them are all corporations. They don't have royal assent.
Great news. Thank you, Michael.
Will I move on?
Yes, carry on.
Okay. Okay. So where no such legal agreement exists, this is we're going back to where we were about proceeding beyond the point recognised onto your property. Where no such legal agreement exists, then the bailiff, who is only a bailiff by title, has no powers of entry unless that authority can be presented in the form of a legal agreement, which must contain upon it 2 wet signatures, one of which must be yours. So a bailiff has no power of entry without your consent to do so. And assault upon the castle is a recognised act of war. So him coming onto your property claiming, oh, well, I've got the authority, I've got the badge, I'm an employee, I've been certified by the sheriff's office, it's a load of codswallop. You can sue him. The very next day, you should be down to the local court lodging a statement of claim for damages, for trespass, for a civil claim for trespass. Yeah, there's a number of case laws which I could run off, but I'm not going to do that now. Deputy, can we move right up to this? I could quote a few. They might be worth a read for some of you people. A bailiff rendered a trespasser is liable for penalties in tort, and the entry may be in breach of Article 8 of the European Convention on Human Rights. So it's also an international human right, recognised human right, trespass and fee simple, right? Your property ownership. If entry is not made in accordance with the law, that was Jokinen versus Finland. It was done in Finland. This is all common law stuff, which applies to us because I know in our courts they do refer to international common law court cases. So don't worry, if they want you bad enough and it works to their narrative and their advantage, they do quote laws from a case law from overseas. A debtor can remove right of implied access by displaying a notice at the entrance. This was endorsed by Lord Justice Donaldson in the case of Lambert versus Roberts, 1981. And placing such a notice is akin to a closed door, but it also prevents a bailiff entering the garden or driveway. That was Knoxon versus Anderson. A lot of this stuff is worth reading. You may never use it in the future, but it's interesting how they actually came to create this case law stuff. Bailiffs cannot force their way into a private dwelling. That's a given. Excessive force must be avoided. That's what they have there. It must be avoided. A bailiff in a court system, in the courthouse, is actually there to protect you from the judiciary. That's what a bailiff in a court is. How they're running bailiffs in the court is the judges and the judiciary are using the bailiffs as protection racket against us. Or we're the ones being summoned in there. We're the ones being accused of doing something wrong. And the bailiff's job, his true position in life, is to protect you and I, the defendants, from the judiciary. He has the power to arrest a judge if the judge doesn't operate correctly at the bench. That's how reversed they've made everything. Yeah, that's very irritating. Okay, so the very presence of the bailiff or third-part company who is engaged in a recognised act of war is an assault on the castle, and it is reasonable for the police officer to arrest the bailiff where there is a recognised act of law. Now, we've seen video where the police are there assisting the bailiff to foreclose and evict the landowner. That's a no-no. The police don't have those powers. If the police officer does not arrest the bailiff on the request of the landlord, then the police officer is guilty by default of an offence against legislation, which is the offence of malfeasance in public office. The police officer is also guilty by default. Remember that. If you've ever been foreclosed on and the bailiff's there to collect and evict you, and he's using the cops to do it, you can sue, get names, collect names, badge numbers, be off against every one of those officers. You watch and they'll stop this rubbish that they're doing. Okay, so that's an overview of what castle rules is. It's an ancient right. It's a right in common law. It's our right. It still applies to this day to all landowners in Australia. Okay, now council rates, pay or not to pay. A fraud cannot be validated with a passage of time. Fraud is fraud. And when fraud is present in a contract, it will make it null and void. Also, fraud has no statute of limitation. A good example of that is if you were in court 30 years ago and the judge wrongfully found you guilty and made you pay a fine or whatever the case is, you can take him and make a civil claim against him tomorrow for fraud. Fraud has no statute limitation. Do they have, another question would be, you could ask with the council rates, or the council is, do they have geographical jurisdiction? Jurisdiction is where authority can be executed. For example, a doctor obviously wouldn't have jurisdiction in a mechanic workshop. That's the same with the council. The council have no authority under the present system of governance. There's freedom of information reports that came out that explains that in detail. That the council is not an entity of the government. It's a corporation standalone. They have no jurisdiction or authority over us landowners. All of us just got to band together and say enough's enough. You have to understand that when the council sends a rate notice, it is not the council that has sent a rate notice. It is a man or woman working for the council that is responsible for the rate notice. The council is a dead legal fiction, like a building. Well, if you don't know who, and we don't, you'll notice rate notices don't come with contact names and phone numbers and signatures and things like that. So the rate notice really is just that. It's a piece of rubbish. What you can do, though, is you can do a civil claim for damages because they're demanding money by malice. That's a serious charge. And you don't know who the person sent the letter. Well, that's so you just address it to the CEO. You find out who the CEO is of your council, and that's who you're suing. He's the top dog. So you sue him. So everyone under him is party to the crime or fraud that they've committed, sending you a rate notice. If there is no name, signature, and there never will be, on the rate notice, then the document is null and void. It's not a contract. If there's no signatures on there, they're not asking you for anything. And it is not an invoice, but rather a statement. And statements are documenting that state payment was done. Have you ever seen a notice where he's got the dollar value they're asking you to pay? Has it ever been a minus figure? It's always the positive. Well, if it's the positive, it means you don't owe anything. It's paid. Then you will write to the CEO of the council and notify the captain of the ship. Remember, they're a ship. The council is a corporation under Admiralty law. Then you will write to the CEO that a man or woman in the council has sent a notice with the fraudulent claims, and that it is the CEO's responsibility to rectify the record. You must rebut every claim on the state rate notice. This is done like so. Write to the CEO and demand that you require presentable material evidence of those claims. Presumptions are no good, and presumptions, terrorism, and guilt is the basis of their world. Never make a claim yourself. Let the law do that for you. So in other words, when you write to these people, you write like a notice of conditional acceptance. And in that would be an itemized list of material evidence that you seek from them that justifies their claim and their authority and jurisdiction against for sending the rate notice in the first place, right? Never be belligerent. Always stand in honour. Always give them the benefit of the doubt. Always ask nice questions, but never ever make accusations, presumptions, guesses. All right. So one example would be rather than make a statement that, oh, you can't do this to me because the Constitution says, oh, you can't do it, you're not part of the Constitution and all that. That's not how you write a letter. A letter is questions. You're asking specific questions that relate to the rate notice. All your information is on that rate notice. So you rebut every part of it. And that starts with the logo? Is that Royal Ascented? It starts with the corporation name in capitals. In a lot of cases, they don't have an ABN. So why is there no ABN? What is your ABN? Because it doesn't appear on the rate notice. Every little aspect of that rate notice, you have to rebut. You have to pull it apart and you need to ask questions for it. And you keep asking those questions until they supply you information. Because they can't supply you that information that falls under the Constitution and common law, they then automatically, by default, they fail for their reason for sending you the rate notice. Okay, so by simply asking them, provide the material evidence that I have a contract with you, signed in wet ink, or a combination of questions below that, but also know what they mean. Otherwise, you could come unstuck, especially when a third party or a collection agent to recover debt comes knocking at your door. I pay rates because I haven't actually got to attacking this as yet, because I've got my hands full doing other things, and I just don't need one more battle added to the list that's active. I'm keeping this for after. So I'm paying rates. Some of my members who live in private don't pay rates. I noticed here in the meeting chat there was a particular individual there. He hasn't paid rates for 2 years. I know of someone who showed me all his paperwork of 200 letters and I think it was about 6 or 7 court. He appeared in 6 or 7 courts, and to this day he hasn't paid since 2016. But he's getting a really hard time trying to live his life in peace because they're at him. They sent the RSPCA around accusing him of animal cruelty. They are doing whatever they can to destroy this man, and mentally he's worn out. He's worn out. So don't take. They're quite powerful. There are ways of achieving this. The fact that they might have left you alone for so many years doesn't mean you got away with paying it. It just means they're waiting for you to either drop dead, so when your family inherit it, the council will step in and say, oh, your dad didn't pay rates for 5, 6, 7, 10 years, so he owes us all that money back. But there is case law that says that council do not have the power to be refunded. And this is under their law. I'm not talking about constitution. Under their statutes, under their legislation, under contract law, they can't claim more than over 6 years for back tax. If they're going to do anything, they have to do it within 6 years. Otherwise, they've lost and they have to give up. Now, some of these questions could be: provide the contract signed in wet ink in accordance with the 2001 Corporation Act, section 127 and 129. Another question is produce the contract in accordance with 2006, section 44, execution of documents. Number 3 could be, why is your document not signed? That's the document referring to the rate notice. 4 is, why 1882 bills of exchange is not complied with. So they're still, even as a corporation with their own legislation and their own acts and everything to follow, they're still bound by our constitutional laws and old acts that are royal assented. They're still bound by those. Why do you have an ABN, an ACN number? Are you or are you not a member and registered with ASIC? Who did you do your oath to? And where is your allegiance to? Provide presentable material evidence that we have a contract. How much GST are you collecting in the last financial year? Under the penalty of perjury, what is the geographical jurisdiction of Australia? Your council. And just for those who don't understand what geographical jurisdiction is, our main continent here is not actually Australia. Norfolk Island is. Norfolk Island is actually Australia under under the geographical. Okay, so Australia really isn't Australia. By not complying with Corporate Act 2001, Section 127, are you not involved in fraud or in the Fraud Act of 2006? Provide material evidence that you are not in malfeasance. So these are just some of the questions you can be asking council. There's a ton. You could make up 100, but you don't want to overburden straight off the bat. What I would recommend is, with your first letter, is actually just stick to questions related to the council notice, because that's what triggers it. That's what starts it all off.
Yeah,
It's like,
Michael, before
Yep.
everyone starts to feel overwhelmed, you actually got together with Steve and a lot of people together to write a bit of a pro forma for this. I'm gonna give away the news at the end, but do you want to share about that?
you mean a template letter that they can send to the
Template
council?
letter.
Yeah,
Yes.
I actually do. In fact, I have actually one in my local council. It's been in there 2 months. I haven't heard peep. I think they're stuck.
So with the
But they still took out, because my rates are paid electronically. They still took the payment though for the last quarter.
right.
They just never answered me.
So now with the template letter, are you planning to share that? Are you sharing it in your group? How?
Do you
what's
want me to
the
put it
idea
up
of that?
here? Do you want me to put it up here in the notice?
That'd be amazing. Thank you.
Okay, hang on. Just have a quick look. So make sure I've got the right one.
Yeah, because we're really glitchy now, but that's okay. We will.
Oh,
Hearing
I
you
can't
all
see
right.
that at the moment. I'm looking at my hard drive. I'm to find the file. I'm very ancient here. I don't have any fancy filing system. Last year, I had everything I had an archive where they just all sat in there loose without being categorized or anything, and then my computer crashed. And so I've, over the last 12 months, have progressively gone through and opened every single file to find out what the bloody thing is, and then put into actual proper folders that separate tax, council, UCC, all that sort of stuff. Okay, so that there is the conditional acceptance. That's the first letter that I used in response to the quarterly rate that I received, and I sent them that.
Where did you put it?
Here in your comments, in your meeting chat, there it's a Word document. Can you see it?
Not me. No, no one's seeing it yet.
Oh, okay, sorry, hang on. Oh, there you are. It's loaded up now. Can you see it?
Aha, yes, there it is.
The
So for the people in the room, you'll be able to download that. And for the people who are watching the replay, then we put that up on the Telegram. I'll put that in the Telegram chat as well.
I have a lot of files which for just council, for rates in council business. I got a lot of files which I'm happy to dump on anyone's Telegram private message if they want for it, and they'll need quite a few weeks to go through each individual one, to learn, to research, to study all the information that's on there, so they get a better understanding of what their rights and what they can and can't, what they can do when they're approaching the council over their rates. That's the first letter, though. That's just to give you an example. And then in there is a breakdown of the questions that I asked them, and they're not the same questions as this one. And I did address it. I didn't address it to the CEO because I wanted to see what the mayor and the assistant mayor had to say about it all first. And obviously they didn't reply. So now I have them in default. Now my second letter will now go to the CEO, which means now I've got 3 people to sue. That's what the paperwork's designed for. It's your evidence to set them up so that they give you information to shut you down. And their information is beautiful. That's what you want. That's the evidence you're going to court with. you're going to use that against them. Especially, you can forgive any corporation sending you a bill the first time because you have the right to decline the offer, right? You don't have to accept the offer. If you have no contract with that company, remember a council is a corporation, you've got no contract with them. Can you ever recall signing anything with the council when you bought your house? There's no contract. So you don't have to do business with them if you don't choose to. And you can send them a nice little letter like that, the conditional acceptance. And they ask them a few range of questions that they need to answer. And if they don't, well, they don't. Okay, well, you don't have a contract. But if they send you a second notice and they title it reminder notice, bang, you now have a civil claim for damages against them because now they're using things, things like extortion, coercion, trespass. As I was saying, going back to trespass law, very, very important to remember, everything can be fought under trespass. They're causing trauma. First, they said you had to pay this and you didn't understand. And then the second one, they're now using threats and force of all sorts, like threatening to charge you a penalty amount or interest for rates not being paid. They're threats. It's a crime. Causing trauma for a lot of people is very stressful. They can get sick from stress. It's a illegal adjudication. They're not judges. They haven't been appointed by higher up in the chain of for a Commonwealth command as a Commonwealth. They have no judicial powers to inflict fines or punishment upon you. You see, you got to think outside the square about who you're dealing with. These are actions they're portraying on you. Before, we never give it a thought. We thought, oh, geez, I owe the money, I should pay. It's how they behave towards you to get that money that you don't have to pay. That's how you got to start thinking at and looking at these individuals.
I also love that you said, it's how we have to behave as well. We can't be belligerent. We have to talk civilly as well and ask the right questions. We do need to upgrade and make sure that our way of being is also in line. I know that when I used to talk to banks back in the day, I used to get really cranky at them and use, sharp tone and how dare they and all this kind of, and I'm talking 20 years ago. But my husband reminded me the other day, and even though I think that I talk politely now, he said, no, you actually have to butter them up. You actually, if they sing you owe money, then if you are the nicest person with them and actually ask them, how's your day, get them on side, get them really loving you, they're actually going to play nicer with you than if you try to go hardball with them. And it takes something. It does when you.
Yeah. And you need to do that because you need, it's like a criminal investigation. You need to be the criminal investigator. And you need to do that like good cop, bad cop. No good being a bad cop. You be a good cop. You be their friend because you don't understand what it is they're doing to you. So you need to get them to clarify. And when you get them comfortable, they start opening their mouth more. They start volunteering more information. And you're born with two ears and one mouth. So when they're talking to you, answering your question, you shut up. You learn what they're saying. They're telling you where to look. They refer to acts and legislation. They're telling you where to look it up. Right? That's how you do it. So always be the victim. You don't have to be the victim. You play being the victim. That way you get more information and they help you. Yeah. Short of filling out whatever form you need, they want you to fill out, short of them filling it out for you, you can get a lot of information from it. And then you can always walk away and, oh, listen, I'm all confused. Maybe I should go and talk to a relative or something like that. Maybe they can clarify. I'm only a simple man. You know, I only know plain English. I don't understand all these big words. Yeah. And that's how you do it.
Yes.
You play with them. Have fun. It's nothing to be fearful of. Just have fun with it. Play them. They've been playing you. They've been playing you, the clown jester, all your life. So turn it back on them. Play with them. Make them work for it.
Now, it is true, though, that if we do have trouble and we do end up in court, the last thing you want to do is have a lawyer. You have to represent yourself. But how often do you think these situations, when we're writing these notices and things, that we would end up in court? Should we expect that to be part of the process?
Well, it depends what court you're talking about. Anyone can go down tomorrow and do a civil claim for damages in a small court, magistrate small court claims, small claims court for a civil. They even give you the form. It's only 2 pages. They give you the form to fill out. Half the form is already pre-text. You just have to write in your personal details and everything, and a bit of summary what your grievance is, what they've done to you, you know. And then you lodge it into the court. They will charge $149, I believe, here in New South Wales. But, you know, the Free Court Act, 1400, all courts are free to us anyway. We just have to ask for it. Otherwise, they'll charge it. And then you lodge it into the court, into the small claims court. And that goes to a back office courtroom. A judge will look at it, read it, see what the complaint is, and then he'll raise what they call a court order. That court order he gives to you, and you serve that court order onto the other party. The other party have 28 days to respond. If they don't, by default, the judge will call it in your favour, and the court will force them to pay you a cheque. Now, in the small claims court, the maximum for New South Wales is $20,000. Most of the other states is a claim up to 25, and WA, unfortunately, they can only claim up to 10. So every state's different, but the process is the same. It's a court held behind closed doors, and there's no attendance. You don't appear. There's no summons to court or nothing. If the other party is being court ordered to produce their evidence or rebut what you've made your claim on, and they feel that they got grounds not to pay and they want to argue it, then yeah, they'll go back to the court and say, no, we want to have a hearing in court. But that's hard. That won't happen if your statement of claim is only listing the information in their infringement notice, because you're not introducing any further evidence or information into it. Don't talk about the Constitution. Don't talk about common law, because the magistrate court and the district court don't care for it. They don't operate under it. They don't like it, because they know they're sitting in fraud and perjury anyway. And if they admit it into the court, they're shooting themselves in the foot, and they're not going to let that happen. They'll rather see you in jail for 10 years than before they are in jail. Yeah. So don't use Constitution. The thing too is common law and constitutional rights, and to protect yourself from their rubbish when they summon you to court. So you are now the defendant. That applies. But when you're a claimant, this is contract law. They build you with something you don't have to pay because there's no contract. So don't worry about the free man, you know, that's the straw man, and You know, don't argue constitutional law, don't argue common law rights. You're in there, you're going straight for the jugular saying, you bastards trespassed on my person, my property, and my freedom. I want to see 20 grand right now. And you're using that information, your claim information, your pleading and your particulars that you state in that statement of claim. It's only information you draw from your infringement notice. And that works for traffic fines. It works brilliantly for traffic fines.
Mm.
You can sue them before they even take you to court. You've got to use the paperwork, especially the first one. When you get a speeding fine, the first one, well, you reply to it. Don't ignore it. You reply to it and you give them a notice of conditional acceptance. You give them the range of questions they can't answer. And then after a month, after 30 days or 28 days, you get a reminder penalty notice or a penalty reminder notice. That's all you need. But you also wait for the letter. Because you sent the notice of conditional acceptance, they also have to reply to it. Their letters are beautiful. It's when you read through it, it's nothing but threat, force, coercion, bribery. It's demanding money with menace, demanding payment with malice. They're all serious crimes, and it's their letter. Their letter doing it. So don't worry about constitutional law. Don't worry about, oh, I'm not driving, I was traveling. Don't worry about that stuff. In fact, when I get pulled over by a cop, I invite him to give me the infringement notice to get the process underway. It's nothing to be fearful of. And mind you, if it was a police officer who pulled me over for nothing, remember the case law Regina, the other case law Hamilton, both of them apply to a cop who pulls you over for no reason. It's the same with the council rate notice. The council rate notice is an invitation to pay. But it's not so much the money, the amount you've got to pay, or arguing about are they constitutionally, you know, royalist centred and all that. It's got nothing to do with that. It's the action that they've written into their own paperwork. That's the crime. That's the claim, because all men are equal. All men, no man is above, no man is has higher authority than the other. You are innocent until proven guilty. You're not obliged to incriminate yourself at all. You don't have to answer any of their questions, but you've got the right to ask all, or as many as you need, to make your case. Yeah.
So I love that. So what can we expect once we have written that? And if we do, will they send us another rates notice in the next few, you know, will they try the process all over again? So just going on what you've seen happen in the past.
It's everything now, regardless of whether it's a parking fine or a speeding fine or some rubbish from some government department, could be not having a fishing license, not having a boating license, could be anything. Anything that's got to do with fining you from any government department, it always ends up going to revenue. Revenue now are the collections agency, and they are coming at us with a vengeance to force us to pay them. What happened maybe just a few years ago was they would fine, they would send a letter out telling you to pay, and if you didn't pay it or ignored it, they would then send third-party collections agencies to handle it. Third-party collection agencies have been failing dismally because we're now better educated in our rights. We're now better educated on what we should be paying and what we shouldn't be paying. And we're telling collections agencies to go stuff yourself. I've got no contract with you, so you can't demand anything from me. In fact, it's a crime if you force me to pay you something that I owe you nothing for, right? They don't have the authority to collect money from you because you have no contract with them. So what happens is what used to happen was they used to buy the fine as a bond. It's a bond, right? All fines are bonds. Anything that's got a signature on it is now a bond. It's sellable, right? So what the government would do would sell that bond at wholesale, maybe argument's sake, half price to a collections agency. The collections agency then would use that bond, pay wholesale, then chase you for the payment, make the difference, plus add his costs. That's how they used to make a living. Those days are gone. Now, if a collections agency received the money, bought the collections and tried collecting on it, and comes and trying to collect from someone like me, I tell him to shove it. He has to sell that bond back. He's been selling it back to the government and making the government go and collect themselves because they can't get anywhere with it. So now the government has adapted to our, or especially to my paperwork. They know my paperwork when it goes through. And so they know exactly where you're coming from when you use it. So what they've done is now they've gone and automated the process. They even moved office, to a secret location, Revenue New South Wales. You can't find a physical address of it. I rang them and I tried all ways of getting to, to find out where located. They refuse to give you the actual location. Everything has to be done by the PO box. This is how crafty they're getting. So you can't even get an email address. It's just a website. They're so untouchable that if you got a complaint with them, you can't even complain to them. You can't talk to nobody. But their whole system is process automated. I'm sure it's a computer just spitting out these notices. Whether they receive a notice from you, someone, obviously a man or woman, handles it, because you do get a reply from it. But it's pretty standard letter. And there's never, on the actual letter that replies to your conditional acceptance, they never have a name of a man or woman, and there's never a signature. Never. So you can't communicate. You're not communicating with anybody. There's someone in that office who's hiding behind the corporate entity. So yeah, and that works the same with the councils. Councils are more exposed than, say, revenue. But eventually, if you don't pay a council rate notice, it will go through revenue, and revenue have been tasked to collect all these rate notices, unpaid bills, for virtually all the government departments.
So don't ignore it when it comes in. Deal with it, but deal with it in the right way.
Yeah, always just rebut it. Who are you? Well, you got an ABN number? What is it? Yeah, and that's the way to do it. But yeah, there's two choices everyone has, right? This is the reality. Contrary to what everyone else is going to tell you, you got two options. Pay the bill and move on, or argue it. Well, actually, there's three. You can argue the bill and go through the quantum series of letters, your first one being your notice of conditional acceptance. Your second one would be default remedy. The third one would be, so you got your process of letters. They're starting to now ignore those. They're not even playing by the rules of commerce, corporate law. They're not even following their own corporate acts. They're just making this shit up as they go along because they got butt hurt by someone smarter than him. Yep. What was that?
I would say then we all better get onto it and do it soon before they start wising up and then changing it again.
And that third option is get them in the court before they get you in the court, and do a statement of claim. It's really not that. 20 grand's not a lot of money, I know, but hey, if you're fighting over a $400 rate notice, 20 grand's a lot of money, because the next rate notice they send you, you can ignore, you can send it back, because you've got a court order found them guilty sending you the notice. So unless they redesigned what they say in those notices, then you're starting all over again. But if they keep to the format, which is probably most likely what they're going to do, because they really don't have a margin of leeway to change anything, because at the end of the day, they know they're committing fraud, making people pay these things. They know it, but they won't tell you and they won't admit it because they've committed a crime. You can sue them for every dollar they got in their private capacity, let alone their employer, who under the Crimes Act has to pay 5 times the amount that the employee was sued for. Read your Crimes Act 1914. It's a good read. It's your price list. You know what to charge them in.
I love that you've got a smile on your face about it. You make it sound so easy.
Okay, now if someone is foreclosing, but it's nothing to fear. It can be simplified. It can be as simple as you make it, all right? But you can get it what they call an injunction. If anyone puts a foreclosure notice or something on your property, if the bank is making moves to take action against you, you go straight down to the court and you ask for an injunction, and that freezes the thing. And then you make a statement of claim and you submit a claim to sue them. And I'm not talking about small claims anymore. I'm talking about big boys court. You know, you can go straight to the Supreme Court, put a $1 million, put a $1 million figure on it, and go to the Supreme Court. Forget the magistrate and district courts. They're rubbish courts. They're nickel and dime rubbish, and the judges are crap. They're imbeciles as far as the intelligence level of judges. The lower courts have got the imbeciles sitting in, right? They're great if you're claiming to sue. That's the only good thing, because they understand corporate law. They're good with corporate law. They have empathy if you are hard done by with a claim of your own, if you can prove it. That's why don't add a claim in your statement you have no evidence for, because an opinion or a presumption does not count as fact. And if you have them in them, if you have one, your whole case can be thrown out, because if one is false, then the presumption is they're all false. So never ever make a false claim on the statement. Only stick, if you only have 2 claims, if there's only 2 issues in there that you want to go for, keep it at 2. Don't do a statement of claim that's 60 pages long. Forget it. You'll be there all year trying to explain every single one of them. Don't do that. That's work. Just 1 or 2 things that's wrong on the infringement. That's all you need to go in. They're the only 2 things you need to argue about, because they're the only 2 things you're making a claim for. I hope I made that.
A lot of people are asking for your Telegram link, because I gave them the title and they can't find it with that, and I can't add it myself. So can you pop in a actual link to your Telegram group?
Okay, hang on. I just have to go grab it for a minute.
Yeah,
you can keep talking while I'm doing this.
Well, you've got a stack of questions that have come through the chat in the last little while.
Well, we can start with
those.
I don't
know that we can answer all of them tonight, because we might be here till midnight. But what I will say is that we have an expo coming up on the 29th of April, and that's at Prospect. And it's at Steve's place. We call it an off-grid property, but really it's not typical in the way that you think of off-grid, because he has the council water and electricity, but he doesn't pay rates, and he is off-grid to the police. And so we want to hear more about that when we get to our expo. And Michael, I haven't asked you, but I presume you're going to be there on the day. It's the 29th of April.
I have no idea. I'm sure I'll be invited, but I haven't. I don't know anything about it.
Yeah, well, we would love to have you there, and we'd love to. We're going to be having talks and demos throughout the day, so you can.
Oh yeah, hang on. Yeah, hang on. I am trying to make it there physically. I remember that now. That's a workshop, isn't it?
That's it. Yes.
Yeah. No, I was invited to that.
4:30.
But if I can't make it in person, there will probably be they'll invite me in by Zoom, so I can be. Because I don't know if most people. I do have a disability, so I'm not very mobile, and I got other health issues. This is why I'm doing what I'm doing, is because if I have it all out there, then everyone can use it, even when I'm gone.
Oh, you're amazing. Thank you for that. No,
That's
we
why I
do
don't charge
have it.
anybody.
Wow. We
I'm leaving behind a legacy for everybody.
That's it. Imagine a year from now, every one of us are not paying our rates, and we're
Yeah,
changing
good to
the
see.
world
Well, I'll
one
be one
letter
of,
at a time.
I'm going to be one of them. Yeah. Yeah. But anyway, if they do foreclose on you, then there's what we call an injunction. You can get an injunction relief. So what that does is it stops dead everything they're doing to remove you or foreclose on your property. And then, of course, it'll have to be taken into court. So you make what they call counterclaim. They've already made a claim against you in a court. They've done it behind your back. So what you do is you make a counterclaim against them. All right? At the end of the day, remember, it's contract law. You can use and quote a bit of constitution stuff, so long as that piece of constitution law is specific to the contract they claim they have. All right. The good one is if you read the Bill of Rights, 1689, Section 12. If you can just remember that, that makes all fines and forfeitures null and void prior to conviction. So if you haven't been convicted for anything they claim against you in a court, then the fine means nothing. It has no value. It's null and void. That's under the Bill of Rights, 1689, Section 12. That alone could get you out of court. Because if you're in court for a fine, you mention it, why did you fine me prior to a conviction? That's against the law. They're not following under the Crown, so they have no authority to do it anyway. See? That one little piece of royal assented law could be all you need to talk the judge into seeing it from your perspective rather than from the prosecutors.
Yeah, it's awesome.
But we don't have a Crown, by the way. So anything a prosecutor brings into a court, regardless of what it is, there's no Crown. Queen Elizabeth died and Charles hasn't been crowned yet. So we don't have a Crown. So why they're bringing Crown cases into the court, I don't know. That's against the law. It's unconstitutional.
Well, we could talk about this all night, couldn't we, guys?
Yeah, there was. Yeah, sorry, yeah, I do rave on a bit, but we're getting back to the rates. I think I pretty much covered most of it. Yeah, I pretty much covered most of it.
Michael, you
Oh, I got a little bit. I got a bit left. There's a little bit I wanted to finish off. There's not much. It's only half a page. Is that all right if I go through that?
Finish that off, and then we'll open up for questions.
Okay. Okay, so we were talking about before, everything is a presumption in law, and any presumption can be dismissed by any formal challenge. That should be imprinted in everyone's memory. It's presumption of law. That's all they have. They don't have facts, right? You just present them. You present your facts, and they can't argue. They can't rebut it. So remember, council workers are either dumb as mud, feel entitled, or work for the UN, or all the above. In around 1999, all government departments were registered as incorporated businesses. So they relinquished all former powers, and to listen to them is like listening to an employee of McDonald's. In 1942, the USA put together the Clearfield Doctrine, the Supreme Court annotated statute. So Clearfield Trust Company versus United States. But that is still applicable to us because Australia, being a corporation, is also a registered corporation as an American corporation under American law, UCC law. We all have, every court is a UCC. It's a UCC law bench, contract bench. So it does apply to us, even though they say, oh, UCC is irrelevant in this court. It's a load of crock. Governments descended to the level of a mere private corporation. If you read the Clearfield Doctrine, it is important to understand this. Remember, it is a mind game they are playing on you. In closing, Whenever they give you documentation, always respond within 72 to 3 days in contract law. Unfortunately, when they send you an infringement notice, it's already gone 3 days before you receive it. This is how they do it. They let it sit on a desk for a day or two before someone takes it to the mail. He who leaves the battle scene first loses. And all letters have similar structures where they're dealing with council, pet registration, council rates, and when dealing with utilities. You can't use the Clearfield doctrine, but all require commercial contracts. They're common. That's common law. So the Clearfield doctrine only applies really to government, courts, and councils. They don't apply to the utilities like electricity, water, and that. But contract law does. If you don't have a contract with wet ink signature from both parties on a contract, you don't have to pay electricity, you don't have to pay, well, we don't have to pay for water anyway. That's actually in the Constitution, water's free. We don't have to pay it. Lastly, there is no magic letter that will stop the council or electricity companies from giving you paperwork. But the better you get at this, you will find that each time you will get someone new, that's when you know it is working. They don't know how to deal with it. So in other words, as you're communicating and corresponding with them, you'll find that the contact that you originally started with changes because it gets flicked to someone either higher up or someone to another department, or it goes to their corporation's lawyer. When that happens, you know you're pushing the right buttons. Just keep persisting with it and ignore whatever threats they throw at you. Well, don't ignore the threats, just ka-ching, ka-ching. That's all you've got to remember. Okay? Always ask for the commercial contract and follow up with the Corporations Act and the 1882 Bills of Exchange. Very important. Our whole economy, every corporation in this country, private or government, is a bank. It's trust law. They use trust law to stitch you up to pay them. All right? So read the Bills of Exchange, because our whole currency system and their whole fiat money, everything's a promissory note. So it explains how promissory notes work and everything. And above all, have fun. This is your line of defense, because you can't be belligerent. Not finished. The end.
Beautiful. No wonder you've got this down, because you're always smiling. So this is the way to go, guys. Gotta have fun with these and play nice. Guys, it's been absolutely my pleasure to bring you Michael tonight, and understanding how not to pay our rates. We are going to wrap it up on our recording, so thank you for anyone who's watching. It really is the place to be live, and so we will have some more questions in the room, but we will wrap up the recording.
Just before I finish off, regarding even the rates, no bill should be greater than $20. So if you get a COVID $3,000 fine, you don't have to pay more than $20 on it. If you have to pay it at all, it can't be more than 20, because then you're complicit in their fraud. Right? And the reason I make that statement is, if you look up the Currency Exchange Act, and if you write this down, the Currency Exchange Act 1965, in combination with the Constitution 1901, Section 115, the highest value tender is gold, is the gold $2 coin. Therefore, must not exceed value more than 10 times its value. So reinstated by a driver's license, and so you can reinstate whatever, and you can, in a few years ago, you could actually ring up Revenue and say, this is the law, and they would accept that. They would actually reissue you the bill for $20. And they reinstate your fines, and you're sorry if they cancelled your licensing. These days, they don't do it because they want you to pay full. They don't like you winning over them. And this is how the mentality works. They got so belligerent and so, but that's it. The Currency Exchange Act 1965, in combination with the Constitution 1901, Section 115. No bill. And remember, we got the Bill of Rights 1689 says we don't have to pay a damn thing anyway, because prior to conviction, if you're given a fine or a rate notice prior to conviction, you don't have to pay it. It's null and void. That's the law too. So there's one or the other. You've got two choices. Pay $20, don't pay anything at all.
Yeah, awesome. Well,
I'm done now, sorry.
We learned tonight. No, we learned so much. Thank you. I've taken a lot of notes, and we'll go back and watch the recording for all the other bit that I missed. So thanks, Michael. Thanks for hanging in there, everybody. And you know, it did take a little while for us to have to lay the foundations, right? We laid the foundations with the types of law, so that when we got to how to not pay the rate notices, that we understood where he was coming from with everything. So it's long, but it was necessary. And really what's necessary is like confronting ourselves. We really have to confront who we are at, you know, when we are dealing with these matters. So we have Michael in our back pocket now. Everyone's got the link to that Telegram group. And if you didn't see it in the chat and you're watching the replay, you can go to My Self-Reliance Telegram group, and the link is in there as well. So thank you everyone for being here tonight, and stay tuned. We do have another really amazing guest speaker up next Tuesday, so come back for more.
Thank you.
Good
Thanks,
night.
Thanks,
Good night.
Michael. Thanks, Jill.
How do we get a recording? Can we get a recording of this?
You can go to Kelly Wilkins My Self-Reliance on YouTube, and you can also find it on my website, so myselfreliance.com.au.
Thank you.
All right, see you all guys next week.
See ya.